Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at another book from Oxford University Press. It's a first-class book, but it's a book that we've got to look at now in a slightly different way possibly because of the changes that have happened since June 2016 and the referendum to leave Europe. I'm recording this in the autumn of 2016 and we've seen quite substantial turmoil so far, a lot of indecision and a lot of very unsure directions in which we might be going. So this book is reviewed on the basis of what we've got at the moment and where we're going in future. The title of it is State Aid Law of the European Union, and the subject matter itself, of course, is controversial, bearing in mind the views of the British people about leaving Europe. The book has been edited by Herwig C.H. Hofmann and Claire Micheau, and it's actually a compilation of many contributors. Elizabeth and I looked at the book and we've given it a title for our book review, A Key Tool for Academics and Practitioners, Important State Aid Information for All UK Lawyers as Britain Embarks on Departure from the European Union. And I think we have to look at it in that way because the public spoke in Britain and they were unhappy about a number of things. Immigration being top of the list, but I have to say also matters concerning aid, international and aid of various sorts. We'll come on to that. This is the book, black cover. It's heavy, it's a hardback. That's the spine. And the back of the book, it runs to something approaching 574 pages. Actually 575. Detailed. The index, very much the house style for OUP. You can see it's page numbering we're looking at here, but a lot of detail. You should be able to find what you're looking for quite easily. There's the front of the index there. Then you've got some annexes, not appendices, but actual annexes. There's Annex 1, which is a table of agreements, and Annex 2, which is the EU anti-subsidy proceedings. Now if we go to the front of the book, you can see there's the front page there, and after that I rather like this. Normally there's a dedication, but this time it's a disclaimer saying that the contributors' views are personally their own. And then of course there's a foreword, which is actually very important because it's a short foreword, but it sets out what the purpose of the book is at the moment. And it was written obviously at the time when decisions were being taken. Now the foreword is written by Marc Jaeger, who's President of the General Court of the Court of Justice of the European Union. And you can see it's a detailed statement from him. And I will be quoting a little bit of what he says because what he says in the foreword is very important. Then you've got the structure of the book itself with the actual contributions clearly set out by the various people in what are actually 6 different parts to it. Then the index at the back. Then you've got a detailed table of contents, so you should be able to find what you're looking for pretty quickly. After the detail, you've got the cases. The cases are structured on the basis of, starts off with the Court of Justice of the European Union, the CJEU, and the General Court. And then after that you can see how the numbering is and how the cases are cited as well. That's quite important if you're relatively new to the subject. Then you've got international cases from the different bodies. That's, for instance, the European Court of Human Rights, the Ombudsman, the World Trade Organization, and so on. Then there's the legislation, again structured in terms of EU law at the beginning. And then we move on from that to list of abbreviations. Very, very helpful in an era where we have a lot of abbreviations, and it's not necessarily the easiest thing to remember what some of these abbreviations are. You can see them there. Then we get the list of contributors, a large number of contributors to this publication. They're all there, a lot of them. I'll mention them again in a minute. I can't mention them all by name. Obviously the two editors are the most important because they've brought everything together. Then you see the structure, that's part 1, and you've got underneath it, you've got a large number of footnotes all the way through. You can see the footnotes running through the book as we go through it. There are some subheads as well, but there's no paragraph numbering. Some of the footnotes are quite detailed. Anyway, it's a heavy book, as I say, runs to under 600 pages. But it's a good book, and I'm pro-European, never been anything other. And so therefore I view this as an important book for us at the moment, as we have to prepare ourselves for what is to come. So what do Elizabeth and I think of the book? Well, we start off with Marc Jaeger, who, as President of the General Court of the Court of Justice of the European Union, the CJEU, as it's abbreviated, describes state aid in the following ways as, quote, one of the sectors in which the EU legal order seeks to find a balance between competition law and member states' support policies to undertakings to achieve a well-functioning and equitable economy. So you can see that the state aid we're talking about here can be extremely important to a local economy. And in the case of the UK, Scotland, Northern Ireland and Wales. So it's interesting to see how people voted, because Scotland voted, of course, very much to stay. Other parts of the UK didn't. There are several current books around, because what the President's done with this particular forward is he said that he gives us a most useful comment as the United Kingdom prepares its Brexit. And much of what has hitherto been accepted as part of our contribution to Europe comes under more intense scrutiny than it's been before with this change of air. And of course, as I say, there are other books available in this area of substantive law. As present, we prepare for these changes, although our view is that Oxford University Press have produced a very clear collection of views with their excellent new title, and it consists of 22 contributions on state aid law in the EU, produced under the general editorship of Herwig, Hofmann and Claire Micheau, and there are obviously very detailed statements from the individual contributors who have indicated it's their personal views, just so that we know where we are. The editors have brought together the rules controlling state aid, and they review subsidies on the EU and the WTO level, which have had a decisive influence on both the regulatory and distributive decision making across the sector, and there are relevant points in the index at the front. So you will have a lot of information at your fingertips should you need further referencing material. And of course, the area of law has expanded exponentially in importance and complexity over the past decades, and we will have to see what happens, certainly as far as the UK is concerned, in the future, because at the moment we have, I think, a very undecided future about where we're going. Of course, rules on state aid and subsidies control are one of the key instruments to ensure that public spending and regulatory measures do not lead to discriminatory distortions of competition, notwithstanding the massive criticisms which have been levelled against what is going on in many quarters. Now, that, of course, has been the uncomfortable reality of the Brexit decision for us. And obviously we're very concerned, many of us, about any domino effect with other countries. However, at the moment we do have this statement. This is a statement of what the law is at the moment, and we have to see where we go. Therefore, of course, virtually no part of national law is free from review under criteria of state aid and subsidy regulation. That's another area, of course, for critical comment by some. And the editors have concluded then, quote, that state aid and subsidies law is linked to economic, constitutional, administrative law of the European Union and the member states, as well as to public international law. And that's where my concern is about the unravelling that we may well get, because we obviously want to try and protect as much as we can of what we've already got. But that's obviously for the politicians and the lawyers to look at afresh. So we'll probably get a new edition of this before too long. The editors bring together leading experts from the academic world, the judiciary, civil servants from the European Commission, and practicing lawyers to offer what they say are the following: expert and valued opinion and commentary on the diverse dimensions of the complex and vital area of law. And that's what they do. And they do just that, as I say, very well indeed. The mission here has been to critically analyse and explain developments and current approaches in state aid law and subsidies. And the chapter heads take account not only of the legal dimensions, but also the economic and political implications, which should be of interest, we think, to British politicians preparing for Brexit. So perhaps they might like to have a look at it. The contributors address relevant EU laws applicable to state aid in the aftermath of the recent state modernisation reform, as it's called. And the coverage includes the following areas, and I'm going to list those. And it's a quote, basically. An in-depth analysis of the notion of state aid as interpreted by the court's case law and the Commission's practice, the rules on compatibility of state aid with the internal market, the rules governing the procedure before the Commission, the litigation before the Court of Justice of the European Union, the CJEU, and analysis of the other trade defence instruments, including WTO subsidy law and EU anti-subsidy law, which you'll find again at the back of the book. And the work, of course, is very heavy on detail, which is what is to be expected. But this clearly is a major requirement for the readers to involved in this area law to have this book. And we thought the footnotes were particularly helpful. Let me conclude with some remarks from Yeager, who rightly says that scholars and practitioners before the Court of Justice should read this book because, quote, it is a key tool to understanding the evolution of state aid, to explore elements of potential answers to the most common and albeit complex questions, and to conceive possible future developments on the subject. And that's exactly what the book aims to do. As I've said, we would add as a final point that the current structure and procedures will remain until we know the outcome of the current Brexit negotiations in 2017 onwards. So we'll probably have another book in due course, and we don't at this stage know what the effects will be on the United Kingdom. So the publication date is cited at 2016, and this is the book again. Let's have another look at it. There's the front, there's the spine, there's nothing on the back. Just opening it in the middle, research, development and innovation. And that's article 107, there we go, straight into it. Very detailed, not too many footnotes on that page actually, but it is. Just go to another page here. The cultural derogation. Lots of footnotes there. And you can see it is actually very complex. Now I go back to the time I did my bar exams, which was many years ago now, decades ago. I did European law. And I wouldn't recognise it by what is going on today with what I actually sat as my exams in those days and what we did at that time, which was a long time ago. So things have changed and they will change again. Thank you, though, to everybody concerned. This is a first-class book. OUP are to be congratulated. Thank you to all. Bye-bye.